Hi there, welcome to this week's video. My name is Sophie and I'm a solicitor at Norris Ward McKinnon. Today's video is going to discuss the changes that the Residential Tenancy Amendment Act 2020 has brought. So these do apply to service tenancies. Now, service tenancy is when you have employees on farm that also live in accommodation provided by you for the duration of their employment. So the first change that has already come into effect that does affect the service tenancies is that rent increases are now limited to once every 12 months, whereas prior to this it was once every 6 months. Now the rest of these changes are coming into effect on the 11th of February 2021. The first one is that a tenant can request to make a minor change to the property and the landlord can't unreasonably decline this. So we get to really understand what a minor change is, whether it's hanging pictures or painting a wall. But I'm sure that there will be some clarification on this going forward. However, it will just be an agreement between you and the tenant and what you consider to be a minor change. So the second one is that a tenant can request that fibre broadband is installed into their property, as long as it's at no cost to the owner, and if it is not, then that can't be unreasonably declined either. The third one is that a tenant can request to assign a tenancy, and this must be considered by the landlord. So you can't unreasonably decline this request. So the way we see it is if one of your employees has been in an ongoing relationship and then they want to move their partner into the accommodation. So they would have to talk to you about this first. If you're on our Federated Farmers Agreements, then there's not much change here, as this does provide for it in the agreement as well. If they wanted a friend or a couple of friends to move in, then this might be a different situation, and you would just have to consider whether that is a reasonable request, or if there's reasons that mean that maybe it's not the best idea to have them in there. Now, the fourth one is that enforcement measures have been strengthened, so that the regulator will now have measures to take action against parties that are not meeting their obligations. So that could be the tenant or the landlord. So that regulator will now be able to just do a little bit more in enforcing those obligations on either of the parties. Now, I guess the biggest overall change to residential tenancies. So a service tenancy is a little bit different, so this won't apply. But if you do also have a residential tenancy with someone, then the biggest change here is that there is has been removal of the 90-day termination notice. So this could be issued to tenants for no reason. That has been removed. So what landlords now have to do is prove that there has been 3 instances of antisocial behaviour within a 90-day period before they can terminate the tenancy. And that actually has to be ordered by the tenancy tribunal as well. So obviously if you've just got service tenancies on farm, then that doesn't apply because you get your 14 days notice period there. However, if you ever were considering whether to put just a normal residential tenancy, a tenant into that accommodation, then just something to bear in mind there. That is security of their rental tenure, and it will be quite difficult to get them out for any reason other than what I've just stated. So that's just a quick summary of the main changes affecting the service tenancies there. There is an article on the Federated Farmers news on the website, so if you want some more information you can go and check that out. Otherwise, feel free to read through the Residential Tenancy Amendment Act 2020 as well, which goes into detail with those changes. Thank you.